Okay, it looks like the last few participants are flowing in from the waiting room, but let's kick off. So thank you so much for joining us for our special International Women's Day 2025 webinar entitled Accelerating Action on Domestic Abuse and Parental Responsibility. We are running for the slightly longer period of 1 hour this afternoon as part of our bite-sized webinar series. And that's to take account of the fact that we have a fantastic guest speaker about whom I will speak more in a moment. So just to run you through what we're going to cover in this webinar, we're going to do some brief introductions. Then we're going to have a Q&A with Dr. Adrienne Barnett, who I will speak about in a moment. And then at the end, in the last 10 minutes or so, we'll have the opportunity for some questions from you guys. I'll start very briefly by saying who I am and who the non-guest speaker who's also in this panel is as well. So my name is Rachel Francis. I'm a barrister practicing in immigration and family law at One Pump Court Chambers. And we're also joined by Roshni Popley, who's a family law barrister at One Pump Court as well. But on to our guest speaker. Our guest speaker is Dr. Adrienne Barnett, as I said. She is a reader in law at Brunel University of London. She practiced as a barrister for over 30 years and is now a door tenant at One Pump Court, and made the move to full-time academia from January 2014. The specialist areas of research by our guest speaker covered for over 28 years are domestic abuse and family court proceedings. Got one extra abuse there on the slide just to make the point more roundly, and more recently looking at domestic abuse and parental alienation. And we're going to be looking at the intersection of those two topics today. Alongside that work, Dr. Barnett is a member of the advisory group of Rights of Women, co-director of Right to Equality, and the UK lead on international strategy group of Hague Mothers. We've popped a little list there of recent publications as well for your interest and further reading after this webinar, and you'll have those in the slides that are sent out after this webinar. So during the Q&A, we're going to be covering the following topics. And once I've been through them, I'm going to get rid of these slides so that you'll just have the three of us in conversation for the next 45 minutes or so. So we're starting off by thinking broadly about parental responsibility, how it's acquired, and the impact of it on victims of domestic abuse. We're going to speak a little bit about applications to terminate parental responsibility, including a specific focus on mothers and on married fathers. We're going to talk about the impact of allegations of parental alienation on restricting parental responsibility. And we're going to talk a little bit as well about legislative change with specific regards to Jade's Law and its partial enactment, and also the developments in respect of suspending parental responsibility of convicted child sex offenders. So, having said all of those things, I'd like to take the opportunity at the outset to ask our guest speaker to just set out a little bit of background, if you don't mind, Adrienne, about your the broad outline focus of your research at the current time, to bring everyone up to speed.
Okay, thank you very much, Rachel, and thanks so much for inviting me, One Pump Court, to participate in this webinar. It's really nice being back, even if it is virtually, at One Pump Court. So my research, essentially, what I have been researching for a long time is looking at how domestic abuse is responded to in family court proceedings, primarily private law proceedings. And since about 2017 or so, I've also been looking at sort of the spread of parental alienation allegations and what happens in the family courts when allegations of parental alienation are made, particularly in cases featuring domestic abuse. As you know, this issue, the whole issue of domestic abuse in family court proceedings featured very widely in the Harm Panel report, and I was commissioned to do the literature review for the Harm Panel report. So those recommendations are now kind of being rolled out, and we're looking at those. And at the moment, I'm doing a project which is funded by the BA Leverhulme Small Grants Project, looking at, it's a small qualitative study which is looking at domestic abuse and parental alienation, featuring interviews with, it's basically interviews with 25 mothers who have been part of a casework project, and then re-interviewing them a year later, and just looking to see how their cases progress, how the courts respond, what's happening to them, to their children. And the other aspect of work I do is around the Hague Convention, hence involvement with Hague mothers. That has been taken off really well. The HCCH, the governing body of the Hague Convention, last year held a forum in South Africa, the first of its kind, looking specifically at Article 13b and domestic abuse, for parents and children who are escaping across borders from domestic abuse. And that went really well. There's going to be another forum in Brazil this year. So we've been doing a lot of work around that. And I'm doing a small judgments analysis on Hague Convention judgments. So that's it in a nutshell.
That's great. And I think Roshni's going to take you through some questions about the conceptual background to parental responsibility. So fingers on buzzers.
Yes, thank you, Adrienne. So to begin with, I think it would be really helpful if you could provide some background to the concept of parental responsibility.
Yeah, so parental responsibility in the Children Act is something that's fairly unique to English law. It's as a distinct legal concept, it was an innovation of the Children Act, and it sort of essentially fragments legal parenthood as a status from legal parental responsibility as a kind of a role in raising children. And the sort of background to it kind of sort of stems from all the big social changes that happened from the 1970s, with increasing divorce rates, more children born outside of marriage, a lot more single mothers. And this kind of led to a sort of crisis for the role of families, the role of fathers in families, where marriage was the traditional unit that tied families together, tied fathers to children. And it led to sort of concerns about so-called irresponsible fathers. This was kind of the discourse that was floating around society. So what policymakers wanted was something to make fathers responsible. Now, of course, this may or may not be any relation to what went on in families, but that was the perception. And it was also a way of trying to take what they perceived as the acrimony out of post-separation disputes by equalising the status of parents. So the Law Commission, the architects of the Children Act, assumed that parental responsibility would sort of encourage parents to behave responsibly and be actively involved in their children's lives. And as the Law Commission said, with the general aim of encouraging both parents to feel concerned and responsible for the welfare of their children. Now, just some conceptual issues with that. A number of scholars at the time, there was a lot of writing and research around this concept at the time of the implementation of the Children Act because of this new concept. And scholars like Carol Smart, like Richard Collier, had pointed out that one of the difficulties is that it divorces the status of parenthood from the actual practice and care, and kind of elevates the status of parenthood over and above the actual tasks of the everyday caring of children, and in that way, because that's traditionally done by mothers, kind of devalues motherhood. The other problem is that it also assumes a power that law has to influence people and kind of change the way they behave. And there was some interesting scholarship around that whole issue at the time. Professor Felicity Kaganas, who retired at the end of 2023 from Brunel, who's one of our leading scholars, had written the 2 seminal articles on the presumption of parental involvement. Now, that's not directly on point, but what she was talking about sort of the way government assumes the power of law's messaging, so, effectively over kind of exaggerates the claims of the power of law. And if anyone, I won't go through it now because it's going off-piste to an extent, but a recently published study, article by Craig Lind, which was published at the end of last year in Journal of Social Welfare and Family Law, looks at this whole idea of the power of law in relation to the parental responsibility, the presumption of parental involvement. He uses a Foucauldian analysis to see how in some ways there are limits to the power of law. It is not something that's monolithic that captures it, but at the same time, it can have very dangerous consequences by reducing, sort of co-opting, as he puts it, adding weight to the desires of the powerful over the needs and safety of the powerless. So that's an interesting angle. But anyway, that it's kind of sort of essentially is the kind of background, what it is, what it was assumed to be. The barking. Yeah. So that's the background to this concept.
Thank you. So moving on to the topic of acquisition of parental responsibility. So how easy is it to acquire parental responsibility? And what is the impact of this on victims of domestic abuse?
Right. Well, just as a recap, I imagine most people attending here know the different ways that parental responsibility can be obtained. It's obviously mothers and fathers who married to the mothers at the time of the child's birth automatically have parental responsibility. Fathers who are not married to the mother and any other persons can acquire parental responsibility in a number of ways. By agreement with the mother, by court order, or by being registered on the child's birth certificate. And that has been the case since 1st of December 2003. So in practice now, since then, the vast majority of fathers do have parental responsibility for their children, either by being married or by having the name on the birth certificate. And in fact, what's interesting is that in 2016, so that was the last time figures were collected on this, only just slightly over 5% of children in England and Wales were registered by the mother alone, and the figure's probably even less now. So, you're talking about a really tiny minority, a small minority of fathers who would not have parental responsibility by virtue of being registered or married to the mother. And it's those fathers who would need to apply for a parental responsibility order, because very, very few parents enter into an agreement. So when it comes to applying for parental responsibility, it is very easy to get. It's very rare for courts to refuse applications. Just to give you some figures, now in 2011, and this is the last year for which this kind of level of detail was reported by the Ministry of Justice, 93.8% of applications for PR were granted, 4.6% were withdrawn, and only 1.6% were refused or no order was made. So that gives an indication. And essentially, the courts apply the CAR test. I'm sure everyone who here is working in this field knows the CAR test, the degree of commitment, the degree of attachment, and the relationship between the parent and child. If one looks at the case law, there doesn't have to be much of a commitment, attachment, or relationship, if any, for courts to grant parental responsibility. And the way that they, even in some pretty dire circumstances, I mean, there were some reported cases where, say, the father wasn't able to exercise it at all, in one case because of mental health difficulties. And the court said, well, there's still a merit in granting it because, it confers rights in waiting. And the way that they kind of get around perhaps granting parental responsibility in what may be considered fairly dire circumstances is by emphasizing the status nature of it, that it doesn't really give anything substantial. It's nothing to worry about. It's just a formal status. It doesn't come with any sort of, substantial rights. And orders are refused in, probably most extreme circumstances. I mean, I won't go through all the cases. I'm sure you can give some good examples. But in the reported cases, there was one, for example, a father who'd been convicted of sexually abusing the mother's older two daughters, really extreme circumstances, often involving convicted sex offenders, that is refused. And the difficulty, I think, with this is this downplaying of the significance of it. And the reason for that relates to something you might want to ask me about, because this is what really creates the problems. I was going to go on to discuss now, unless you want to bring in some examples, the whole issue of what's arisen about the duty to consult and the whole issue of decision making.
Yeah, I think that would be really helpful. Thank you.
Right. So, parental responsibility, as we know, doesn't relate to having contact with the child or the physical or emotional care of the child. It's essentially about sort of decision making and being able to, say, have access to things. And there's some sort of pretty important things that a parent with parental responsibility can or can't do, such as withholding consent to adoption, objecting to a child being accommodated by a local authority under Section 20, consent to the permanent removal of a child from England and Wales. And then again, there are areas where, which are pretty fundamental, which a parent doesn't need parental responsibility for. For example, having a right to apply for a Section 8 order, or conversely, being obliged to pay child maintenance. But so you can see there's already some pretty important decision making that a parent with parental responsibility has, particularly this needing their consent to removal from the jurisdiction. But added to that, the courts have developed a duty to consult, which wasn't isn't in the Children Act and was not envisaged by the Law Commission. In fact, the Law Commission specifically said, we believe it important to preserve the equal status of parents and their power to act independently of one another, unless and until a court orders otherwise. A legal duty of consultation seems both unworkable and undesirable. And that's why the Children Act says that parents can act alone to meet their parental responsibility. But through the case law has developed a duty to consult, possibly a duty to agree, it's not really clear, on certain important issues concerning a child's upbringing. And that started with the case of Regi in 1994, in which the courts held that there's a duty to consult about important steps in a child's life, such as, in that case, changing the child's school to a boarding school. And then it's been extended to include things like medical decisions, circumcision, whether the child should have the MMR vaccine, and so on. But Lady Justice Butler-Sloss, in a case, had said it includes the right to be consulted on schooling, serious medical problems, and other important occurrences in a child's life. Now, there's scholars like John Ekelar, one of our most well-known family law scholars, has critiqued this duty to consult. He points out it's badly defined. I mean, who knows in advance what is an important issue in a child's life until the court says it is? And what amounts to consultation? Is agreement necessary? Because in some of the cases, it talks about the father must be consulted and agreement obtained. In other cases, it simply says consultation. And then how can it be enforced? So what happens if a parent doesn't consult? And there's some quite interesting research, early research, because one of the things about this whole concept of parental responsibility is that there's actually very, very little recent research on it. But some earlier research looking at patterns of post-separation parenting found that there's actually very little joint discussions, cooperation around decision-making. A study by Liz Trinder and others in 2005 found very low levels of joint decision-making. 78% of parents never discuss their children's problems together. An earlier study by Mavis McLean and John Ekelar said that joint decision-making of any serious nature probably occurs only in about 1 in 10 cases. However, with this duty to consult in other areas, this can give enormous power to domestic abusers, even if they may not have any substantial involvement in their children's lives, particularly if they don't. It can give great power to someone who may not know a child very well, to be able to exercise control over the child and the other parent. And that is one of the huge issues, requiring consultation. All they need to do is, create a veto over anything, say, that the resident parent wants to do. And it's particularly problematic in the area of mothers, say, who are victims of domestic abuse and children who want to leave the jurisdiction permanently or even move to another area.
Yeah.
Because, as you know, the case law is developed from on internal relocation, where it used to be almost unheard of for one parent to be able to stop the other parent moving to another part of the country. When I was in practice, I mean, nobody would have got that off the ground, really. Whereas now, it's actually, it happens in more and more cases that, say, a mother and child, can be stopped from moving. But internationally, it is a big problem. Having that power of veto and being able to wield Hague Convention proceedings because that parent has parental responsibility, is a very powerful tool in the hands of an abuser. So
Yeah, I
what
think
was
it's really interesting because Roshni and I were talking about this in the run up to the webinar about the kind of conversations that we end up having with clients and how practically difficult the clients perceive it, that they are supposed to exercise this PR in a joint fashion, that they are supposed to consult. And as you say, exactly that issue, the future is unknown to the parent when you're working with them. And so it's very difficult for them to anticipate what situations the court anticipates in its own mind that they might need to consult someone on. And I mean, within the juniors at One Pump Court, we sometimes go back to this case. There's a case from the High Court, which is A&A 2004. It's EWHC 142. And at the end of that, Mr. Justice Wall had set out a list of things that decisions that would need to be made jointly, decisions that could be made in a kind of ordinary exercise of PR, but it's a non-exhaustive list. And I entirely agree with you. And I know Roshni has reflected the same from her practice experience, that it creates this kind of looming shadow over the parent who is de facto parenting day to day as to what issue may come up and whether they may find themselves back in court. And that power is one that is not just exercised within the currency of litigation, but afterwards. And it's pretty unsalutary. It's a piece of advice that you have to give a client, and feels very kind of discordant with trying to take a more expansive, holistic and supportive approach to victims of domestic abuse in the family courts. So it's really interesting to hear you talk about it from a research perspective and what was not anticipated when this kind of conceptual idea of parental responsibility was brought into legislation.
Yeah. One of the interesting things of this is a much earlier piece of research, I think a US study by Manukin and others, found that non-resident parents felt that they had a lot more consultation and communication and decision-making than they actually had, or than, say, the resident parent had, because they simply weren't aware of all the day-to-day decisions that went on. So they kind of overestimated the amount of decision making that they thought they had. And there's sort of a whole thing about parallel parenting, where parents simply found the easiest way to get on to manage post-separation life. If there was conflict, if there's an abusive relationship, was non-communication. And that makes it even more difficult, doesn't it, for say a victim who wouldn't even ordinarily have much communication to then think, am I expected to, discuss skills? Are we expected to go to open days together? I mean,
yeah, absolutely.
I agree. Yeah, it's a kind of unsatisfactory state of affairs, really.
This relates quite closely to a case that I'm on at the moment, in private law children proceedings. And the parents live in different countries, and findings have previously been made against this father of a pattern of coercive and controlling behaviour. And one of the mother's applications is to restrict his parental responsibility to enable her to make all of the daily decisions around health and education without consulting him. Because as you said before, Adrienne, the parental responsibility itself gave him, or has given him, sort of an extra power over her. And she's alleging that he's used his parental responsibility to continue that abusive behaviour. So, undermining her daily decision making around the children, and complaining about her parenting and the decisions that she's been making on a daily basis, and making threats to take matters back to court and various matters like that. So I think has a number of parallels with what you were speaking about, and what the court will be considering at the final hearing is, what they can do to, whether they should restrict or limit his parental responsibility, because from his perspective, he wants to be involved in his children's life. He feels that he's entitled to be, demanding information about various matters about their lives. So
yeah, that's kind of the one of the problems, and particularly the problem which, that kind of exercise of parental responsibility is precisely what was not envisaged by the Law Commission when they created this concept. So that is a problem with the way it's developed, I think, and this sort of loose boundaries about what needs consultation. But certainly that kind of day-to-day kind of micromanagement is not on under any interpretation of the law. And it was precisely for this reason that the Law Commission didn't decide on granting automatic PR to all fathers, because they did look at it very carefully, and there were arguments made on for and against, but they came down. They actually said the most powerful factor influencing our decision was a strong body of evidence from those best acquainted with the problems of the single-parent family about the vulnerable position of the unmarried mother in many cases, who may be exposed to pressure and harassment, etc., etc. And so it was recognised, but I think the ease with which it can be obtained and this growing duty to consult has led to just that kind of situation that the Law Commission was trying to avoid.
Yes. So moving on to our next topic now. So applications to terminate parental responsibility. So from your own research, how common is it for the court to make an order terminating the parental responsibility of perpetrators?
Right. I have not done, as I say, my research is focused primarily on what used to be called contact, child arrangements, etc., etc. We don't know how many applications there are to terminate parental responsibility. The year before last, when there were the debates around Jade's Law, which we're going to talk about in a minute, there was a House of Commons debate, and they'd referred to only 4 applications in 20 whatever it was years to terminate. Now that wasn't correct. I think they must have been referring to 4 particular published judgments. However, my colleague and friend, Dr. Sonia Ayub Carlson, who's an associate professor at UCL, has done some research on parental responsibility applications, how to terminate, which hopefully will be published soon, and found that there were, not only 4, but very few, very few applications to terminate since the Children Act was implemented, and it's very rare for now, just so that everyone's aware, and I'm sure most people are, if you have acquired parental responsibility automatically, in other words, mothers and married fathers, your parental responsibility can't be removed. It can only be removed if you've acquired it by one of the other means, agreement, order, or registration on the birth certificate. So it's those parents we're looking at in terms of removal. And what the case law shows is that it really is in the most extreme cases that the courts may be willing to remove a parent's parental responsibility. The kind of cases that get reported are very often for convicted, sex offenders, that sort of level. Very extreme. There was one where, it was the father who was convicted of sexual offences against the mother's 2 daughters, got a 2-year prison sentence. His parental responsibility was removed. But even in that case, that was a decision by Lord Justice Ryder. He went on to say that, emphasising the importance of continuing relationships between a child and both parents. And he said the significance of the parenthood of an unmarried father should not be underestimated. So even then, trying to really emphasize it. So it's not that easy to get it terminated. Having said that, I think the courts, from research I've recently undertaken into the presumption of parental involvement, the courts do seem really to be gaining a better, a good understanding, or some of them, of domestic abuse, of the effect on children and victims. So it may be that we'll see not quite such a strict approach to terminating parental responsibility. There was that case by where Mr. Justice Hayden, F&M, said, this was a married father, he said, but if he could have removed his parental responsibility, he would have. And that was a case of coercive control. So, but in cases where the court can't remove the PR, then as in the case you mentioned, Roshni, then they would tend to restrict it. In other words, make prohibited sex orders to effectively prevent them. But even those are relatively limited.
I wanted to jump in because we've had, and I'm really grateful to you for going through that so expansively, Adrienne. We had a question which was about, this actually popped up when we were talking about the acquisition of parental responsibility. And the question was, are there any successful examples of fettered parental responsibility being granted that you are aware of? And in what circumstances may this be appropriate? So I think that question was looking at, in the granting of parental responsibility, can it be fettered at that point? But the example I wanted to give was the opposite example. So where a parent has acquired parental responsibility, in this case it was a married father, and that parental responsibility was substantially fettered. It's a case that I won't go into the case detail because it was a very, very serious case, but it involved a mother who survived an attempted murder by the father, one in which the child took steps, or one of the children took steps to intervene in the incident in which father tried to murder the mother. And the court made a very comprehensive suite of orders to assist the mother and the children in recovering from this horrifying incident. So there was a non-molestation order made for the duration of the children's minority, with all the components of zonal exclusion, non-contact for both mother and children. Permission was given to the mother to change the children's surnames because the children shared their biological father's surname, and that was a source of great upset to them and great trauma. There was a lives with order made in favour of the mother, and an order for no contact for the duration of the children's minority. And then in respect to parental responsibility, cross orders were made. So an order was made in favour of the mother, specific issue order, enabling her to exercise parental responsibility to the exclusion of the father, and listed what that would
sort of said, but it could be beyond that. And then there was also a prohibited steps order made against the father, preventing him from exercising his parental responsibility, including in the following ways. And he was not permitted to take any steps to identify where the children lived or the school they attended, or to obtain health and schooling information. So it was this extremely thorough order, and actually an order that in the end was made by consent once the father had obtained representation. But that was the mechanism really to give effect to the protection that the mother needed, because her ability to parent the children had been profoundly compromised by the extent of her injuries, but also by the trauma that they'd all suffered. And that was the mechanism. But yeah, I mean, I wonder whether this is kind of a helpful place to kind of draw the conversation towards. Either it's up to you, Adrienne, whatever you feel would be most appropriate. It could be about parental alienation and how that's competed with the fair exercise of parental responsibility, or it could be looking from a more legislative perspective, so Jade's law, and so on. Whatever you think.
Okay. I'll start off by responding to the question, interesting question from the chat. Yes, absolutely. There have, in fact, been cases where a court has granted parental responsibility, but restricted it a bit. There was, I don't have the case at hand, where there were two mothers in a same-sex relationship, and the father was a friend, and then they had a fallout. And he was applying for parental responsibility. And what the court did in the end was grant him parental responsibility, but restrict it so that he couldn't, to make it clear who was the main decision-making unit. So yeah, that there's no reason that can't happen. And yes, courts can do that. And it may be that they are more willing to do that in more complex cases where you know, they feel a PR order ought to be made, but there may be complications like that. Yeah, in relation to restricting parental responsibility, yes, I think courts are more willing to restrict it than to remove it altogether, and that is one way in which they can manage it. Very often, you know, if it's a case where, for example, they're all perhaps ordering limited or no contact, or perhaps indirect only, and there's issues with PR, then that can go part and parcel. But one of the other sides of the restricting parental responsibility in much more recent years is seeing a growing number of cases, and not many reported cases, I have to say, but although I haven't done a specific search on that, of mothers having their parental responsibility restricted if the court decides that they are alienating. Now, you know, there's been a lot of focus, a lot of research, well, some research around the whole issue of parental alienation, and I have done some studies on that, but it tends to be focused on contact, on child, you know, the child's living arrangements, contact arrangements, etc. There really hasn't been that much of a focus on how allegations of parental alienation are operating with regard to parental responsibility. But there have been a couple of cases. There was one case last year where the father had applied for the mother's parental responsibility to be restricted on the basis that she was sabotaging his time with the children, his parental responsibility. And the judge took a dim view of the mother, but in that case declined to do it because that was a shared parenting arrangement, a 50-50 shared parenting arrangement. And the judge took the view that he said there was no reported precedent for an order depriving a fully engaged carer of significant elements of their parental responsibility. Now that's quite interesting. So what he's saying is, if there's a shared care arrangement like this, how's the mother supposed to exercise her care if her PR is restricted? But on the other hand, there were other cases. There was one case called Re A and B, parental alienation. There were 6 judgments to date in that case, a case that was heard by Mr. Justice Keehan, in which the mother was found to be alienating. And so by the end of it, she was ordered to have no contact at all with the children. The children had been removed from her care and moved to the father. No contact at all with the mother, direct or indirect. And he made orders completely stripping her of her parental responsibility. He said it is imperative in the children's welfare best interest that she, the mother, plays no future role of any description in their lives and isn't able to exercise her PR. So I guess, I mean, some of you may have read my research about how allegations of PR can be used themselves as a tool of abuse by abusers against victims of domestic abuse, and removing a mother's PR perhaps is another element in that. but there may be more cases, but those are, that one sticks out. In terms of moving on finally to the
Yes,
law.
please. That would be great.
Yes.
Thank you so
Yeah,
much.
'cause I can see
Such
the
good
time's
time.
moving on. Yeah, okay, so Jade's Law. So I think everyone knows Jade's Law arose out of the murder of Jade by her ex-husband Marsh. And he was given a life sentence. And then the issue for Jade's parents, who were looking after the children, was that they had to consult with their daughter's murderer in prison about decisions relating to the children. And so they led a campaign for parental responsibility to be removed or suspended from convicted a parent who killed the other parent. And finally, this happened. It was enacted last year in Section 18 of the Victims Imprisonment Act 2024. So I don't think we've got time to go into the finer details of it, but essentially, if a parent murders the other parent of their child or children, then the Crown Court must make a prohibited steps order completely restricting the exercise by the murderer parent of their PR until the matter is heard by the High Court or the Family Court, and until it's varied or discharged. Also applies in the case of manslaughter, where the offender would have been liable to be convicted of murder were it not for a defence of loss of control or diminished responsibility. So that's Jade's Law. Sorry, the latter point, the sort of the caveat for that is to exclude from the categories of restricting PR cases like Sally Challen, where a victim.
Yes.
Yeah. So that's Jade's Law. However, during the passage of the Criminal Justice Bill last year, Harriet Harman, MP, had tabled an amendment to provide for automatic suspension of PR for anyone convicted of serious sexual offences involving or related to children. Now, that wasn't accepted. That was opposed by the government. They thought it was too broad, and so it got withdrawn. It came back a bit later. I think it was, during the Lord's stage last year, Shami Chakrabarti had moved an amendment for suspension of PR from someone who was convicted of a sexual offence against a child in the family. And that was, again, opposed by the government, too vague. However, the government itself then tabled an amendment to the bill to extend to cases where someone is convicted of the rape of a child. They would have their PR automatically suspended. And that would have got through were it not for the fact that the Criminal Justice Bill fell when the general election was called.
Right.
So we're back to square one again.
Yeah. I mean, it's interesting because the theme of International Women's Day this year was accelerating action. And I wonder kind of where we're coming to that sort of the point of closing this webinar and asking if there's any other questions, but bearing in mind the kind of precipice that we got to with that.
Oh, well, we're not giving up.
Yes, exactly.
It's going to happen.
What action is it that you would say should be happening? What should we be accelerating now in relation to domestic abuse and parental responsibility?
Well, we should certainly be accelerating legislation to provide similar suspension for, at the very least, a parent convicted of a sex offence of a child in the family. There are a number of legislative vehicles going through Parliament at the moment, the Children's Wellbeing and Schools Bill, the Victims' Courts and Public Protection Bill. But I think we need to look a bit wider at cases where parental responsibility should be suspended. And I think we need to look really seriously at this duty to consult
Yeah.
And if there is going to be a duty, it needs to be properly defined so that parents know what they're doing, and it should not be able to be used as a tool by abusers. It needs to be realistic. Personally, I think a duty to consult full stop is unworkable, but that's something that I think needs looking at. And certainly for leave to remove cases, that needs to be looked at again. It's too harsh on victims of domestic abuse.
Dr. Barnett, it's been so brilliant to have you here to talk with such significant expertise about this topic and to take us uphill and down dale on all of the different issues that we set out to cover in this webinar. I haven't seen any more questions come into the chat, but I will just give people a last opportunity to pop a question in. The fettering of parental responsibility at the point of acquisition was a great question. If that person wants to ask another one, please do. If there are any more, we'll give a few minutes. But we're really grateful to you for giving your time and your energy and commitment to this issue, to this webinar this afternoon.
Well, thank you so much for inviting me, taking part. It's been excellent to hear, from the cold face about your cases. Really, really interesting and important. And thank you very much. Yes.
Thank you. We have no further questions, so I think we will release everybody 5 minutes early. But thank you again to Adrienne for joining us, and thank you to all of you for joining us for this International Women's Day special webinar. Oh, hang on. No, it's the same one again. Oh, I don't know. I'm not sure I understand that question, so I'm going to bring us to a close. But thank you so much for joining.
I think they're asking, when is the recording going to be available?
Potentially. So we will defer to our PR person, Emma Smith, who will be sending that out shortly along with the slides. And so you'll be able to watch back and hear all of Adrienne's expertise all over again. But thank you so much, everybody, for joining us, and we'll bring that to a close. Thank you.